Good evening, everyone. I hope you guys are doing absolutely fine. So, as we say, let's start with today's session. Today, we'll be basically covering the entire uh, legal monthly roundup of month of May. There were very important judgments, and there is also an ordinance passed by the Honorable President of India. We'll cover all those things. But to start with, we have the first important news item in today's session, and we'll start with that. So basically, recently, the Supreme Court of India passed a very important order, right? And this order was passed with reference to the Rights of Persons with Disabilities Act. Now, why this particular order is important? Let's understand it. This particular order in detail. So basically, the Supreme Court of India in this particular order basically, removed the difference between victims of acid attack. Now, till this date, there was a classification when it comes to the victims of acid attack, and this classification was made on the basis of कि आप पर attack कैसे हुआ, whether it's an external attack or internal attack. Now, external attack, so everyone knows what do we mean by external acid attack. But what is internal acid attack? When there is a case of forcible acid ingestion. Now, students, what is forcible acid ingestion? What is forcible acid ingestion? So, forcible acid ingestion is basically when an accused basically forcefully, uh, you know, causes the victim to consume the acid, right? जब आप किसी को forcefully acid consume करने के लिए force करते हैं तो उसे हम क्या बोलते हैं? Forcible acid ingestion. Now, till this particular point, there was a difference between the external attack and the internal attack. External attack में क्या होता था कि आपके ऊपर किसी ने acid फेंक दिया, so you will get the benefit of you will get benefits under the Rights of Persons with Disabilities Act of 2016. But if there is an internal attack, if you were you were forced to drink acid or you were forced to ingest acid, then you will not be considered as a victim of acid attack, and you will not get the benefits under the Rights of Persons with Disabilities Act 2016. So in this particular case, Shaheen Malik versus Union of India, Shaheen Malik versus Union of India, the Honorable Supreme Court of India has diluted this particular difference by utilizing the powers given under Article 142. Now, what is Article 142? So we have a lot of discussion around Article 142, and Article 142 is basically the power of Supreme Court to do complete justice. And also, students, we have to understand the reasoning given by the Honorable Supreme Court of India while diluting the difference between the external and the internal attack is outstanding. Right. So let's start with this particular topic. So the Supreme Court expanded the Right to Person with Disabilities Act 2016 to recognize survivors of forcible acid ingestion as acid attack victims, extending disability rights, compensation and legal protection throughout a deemed amendment under Article 142. So basically, the Supreme Court of India has expanded the definition of persons with disabilities under the Rights of Persons with Disabilities Act 2016 by diluting the difference between the victims of the external acid attack and the ones who were forced to ingest the acid. And this particular order was passed by using the powers given under Article 142. Right. So now move to the next point. Let's move to the next point. The court has observed that the person forced to consume acid are entitled to the same disability benefits as those who suffer external attacks. Right. So there is no difference whatsoever. Right. If there are external injuries and there are internal injuries, but those injuries are caused because of the acid attack, then you will get the same benefits under the Rights of Persons with Disabilities Act 2016. Now, also the Supreme Court have made it absolutely clear that the logic is very simple, that when we talk about victims of acid attack, students, then there is a very important section which is section 124 of Bharatiya न्याय Sanhita. Now students, what is section 124 of Bharatiya Nyaya Sanhita 2023? So let's understand section 124 of Bharatiya Nyaya Sanhita 2023. It talks about the cases related to acid attack or grievous hurt. Now students, the Bharatiya Nyaya Sanhita 2023 does not differentiate between the victims of acid attack, whether these victims are of external acid attack or internal acid attack, right? The punishment is absolutely similar. If it accepted both the act of acid throwing and the administration of acid as offences punishable with imprisonment from 10 years to life sentence under section 124 of Bharatiya Nyaya Sanhita. Right. So section 124 of Bharatiya Nyaya Sanhita does not differentiate between these two kind of victims. So the Supreme Court of India used a similar logic that if the criminal law does not differentiate between these two kind of victims, then why there is such a differentiation, right? And that's why the Supreme Court of India took the help of section 124 to justify its order passed under section 1 under article 142 of the Indian Constitution, that if there is no difference between the types of victim or the kinds of victims under section 124 of Bharatiya Nyaya Sanhita, then they are entitled to get the same kind of benefits under the Rights of Persons with Disabilities Act 2016. And with this particular order, the Supreme Court of India has absolutely diluted the difference between the टू काइंड ऑफ एसिड अटैक विक्टिम्स. अब इन दोनों को एक ही तरीके का विक्टिम माना जाएगा. देयर इज नो डिफरेंस एट ऑल. नाउ मूविंग ऑन, the court has formally included survivors who were forcibly administered or forced to ingest acid previously. The Right to Person with Disabilities Act 2016 only covered individuals disfigured by throwing of acids. The ruling clarified that victims suffering from severe internal organ damage due to acid exposure are fully entitled to protection and disability benefits even if they do not exhibit any visible external disfigurement. So basically the Supreme Court of India, again the logic is very simple. इंजरी एक्सटर्नल है या इंटरनल है, इट विल नॉट डिफाइन वेदर यू आर अ विक्टिम ऑफ एसिड अटैक और नॉट. द ओनली थिंग विच मैटर्स इज कि एसिड का यूज किया गया आपको एक्सटर्नल या इंटरनल इंजरी कॉज करने के लिए, और सिमिलर लॉजिक है, सिमिलर लॉजिक का यूज किया गया जो सेक्शन 124 ऑफ भारतीय न्याय संहिता में. सेक्शन 124 ऑफ भारतीय न्याय संहिता डज नॉट डिफरेंशिएट बिटवीन द टू काइंड ऑफ विक्टिम्स. सो द रीजन इज वेरी सिंपल. एसिड अटैक होना चाहिए, डजंट मैटर कि इंजरी इंटरनल है एक्सटर्नल है. सेक्शन 124 भी डिफरेंशिएट नहीं करता. इसी वजह से सुप्रीम कोर्ट हैज पास द ऑर्डर बाय यूजिंग द पावर्स गिवन अंडर आर्टिकल 142 ऑफ द इंडियन कॉन्स्टिट्यूशन. There is only one category of acid attack victims, that is victims of the acid attack. No difference at all whatsoever. Now moving on to the next part of this particular judgment. So the act was, so basically this is a background of the Rights of Persons with Disabilities Act of 2016. So the act, this particular act, Rights of Persons with Disabilities Act 2016, was passed in India because India was one of the signatories. India was one of the signatories of Rights of Persons with Disabilities, United Nations Convention on the Rights of Persons with Disabilities. So India is basically a party to this convention. This particular convention came into existence long ago, but India ratified this convention in 2007. और जब हम किसी इंटरनेशनल कन्वेंशन को ratify करते हैं, then we have to ensure कि हम उस कन्वेंशन को अपने कंट्री में फुल्ली इंप्लीमेंट करें. और इस कॉन्टेक्स्ट में आर्टिकल 253 है, वो आप एक बार देख सकते हैं, राइट, कि जब हमें किसी इंटरनेशनल कन्वेंशन को अपने कंट्री में इन्फोर्स करना होता है, देन द प्रेसिडेंट ऑफ इंडिया कैन पास एनी ऑर्डर, राइट. वो दैट इज गिवन इन आर्टिकल 253, राइट. सो दिस इज एंटायरली अबाउट दिस टॉपिक. इफ यू हैव एनी क्वेश्चन व्हाटसोएवर फ्रॉम दिस पर्टिकुलर टॉपिक, यू मे आस्क योर क्वेश्चन बिकॉज दिस टॉपिक इज एक्सट्रीमली रेलेवेंट फॉर योर एग्जामिनेशन, राइट. द विक्टिम्स ऑफ एसिड अटैक, राइट. और वो जो लीगल रीजनिंग में वो माइनर टॉपिक्स पूछे जाते हैं अपार्ट फ्रॉम द कॉन्स्टिट्यूशन ऑफ इंडिया, इंडियन कॉन्ट्रैक्ट एक्ट, लॉ ऑफ टॉर्ट्स एंड इंडियन पीनल कोड, एंड तो उसके अलावा जो कभी एक दो पैसेज माइनर एक्ट से पूछ लिए जाते हैं, उस पर्टिकुलर कॉन्टेक्स्ट में दिस टॉपिक इज एक्सट्रीमली रेलेवेंट, राइट. नाउ मूविंग ऑन टू द नेक्स्ट इंपॉर्टेंट टॉपिक दैट वी हैव विद अस इज इन टुडेज सेशन इज बेसिकली teen rape survivors choice versus unborn babies right to life, how Supreme Court's new order deviates from the precedent. So recently the Supreme Court of India has passed an order allowing the medical termination of pregnancy and the pregnancy was 30 to 31 weeks old, and it was related to this pregnancy was related to a 15-year-old rape survivor. Now finally the Supreme Court of India has allowed the victim to terminate her pregnancy even though the fetus was absolutely healthy and fine. But again, the Supreme Court of India has said that 15 years is basically is too young for a girl to become a mother. When she is already a child, then how could she give birth to another child? This was the logic used by the honorable. You can write down the major points. You don't have to write out jot down the entire points. You just write down the important sections and the points. That's it, right? So this is the background. There was a rape survivor. She was 15 years old. She was carrying a pregnancy of 30 weeks old. Her pregnancy was 30 weeks old, and she was basically demanding from the court that she should be allowed to terminate her pregnancy. Earlier the Delhi High Court said no, we can't allow the termination of pregnancy. Then they moved to the Supreme Court of India, and finally the Supreme Court of India allowed their pregnancy under the Medical Termination of Pregnancy Act 2021. This 1971 act was amended in 2021, right? So the Supreme Court refused to entertain a curative petition. Now students, please remember this, the idea of curative petition. What is a curative petition? Anyone who would like to answer the question, what is a curative petition? Anyone? What is a curative petition? So basically, students, the idea of curative petition flows from Article 137. When the review petition is also dismissed, then you can file a curative petition when there is a gross miscarriage of justice. So it was a gross miscarriage of justice because the victim was too young. She was a 15-year-old girl, and she should have been allowed to terminate her pregnancy, right? So the Supreme Court of India, and this particular petition was filed by All India Institute of Medical Sciences, Delhi, and the central government कि उस particular रेप सर्वाइवर को अलाउ नहीं करना चाहिए अपनी प्रेगनेंसी को टर्मिनेट करने के लिए. द कोर्ट नोटेड दैट फोर्सिंग अ माइनर टू कंटिन्यू एन अनवांटेड प्रेगनेंसी वायलेट्स अ डिग्निटी, mental health and constitutional rights under Article 21. So again, the Supreme Court of India has given primacy to Article 21, that is right to life. The Supreme Court of India recognized different facets of Article 21, that is dignity, mental health, and she does not want to continue her unwanted pregnancy, right? Now moving on to the next important point, the court held that strict time limit in the MTP Act cannot be applied to deny termination in cases of child rape. So basically the Supreme Court of India somehow created an exception for the Medical Termination of Pregnancy Act. कि Medical Termination of Pregnancy Act में there is a strict time limit for the termination of pregnancy, but the Supreme Court of India said that we cannot allow these terminations. We cannot allow we cannot strictly follow the time limit given in Medical Termination of Pregnancy Act, because there has to be some exception, because victim is a child and she's a victim of rape, right? एक तो child है, ऊपर से rape victim है. So this will act as an exception to the provisions of Medical Termination of Pregnancy Act. Now what are the key observations of the Honorable Supreme Court of India? So the first one is reproductive autonomy. The court ruled that the decision rests with the minor and her parents, not the doctors or the state. So basically the Supreme Court of India has recognized the reproductive autonomy and said that कि उस particular pregnancy को terminate करना when the victim is the survivor of rape, it purely depends upon the minor and her parents. It will not be decided by the doctors and the state, because the stakeholders are minor and her parents. Doctors or state stakeholder nahi hai, so it would be decided by minor and her parents. The Supreme Court urged the union government to amend the Medical Termination of Pregnancy Act to remove time limits on termination for minor rape survivors. So basically, after this particular order was passed by the Honorable Supreme Court of India in this case, the Supreme Court of India has also requested the union government that they should create an exception for the minor rape survivors in the Medical Termination of Pregnancy Act 2021. Now moving on to the next important point. On May 4, 2026, the court dropped contempt proceedings against the center and AIMS after they complied with the directives to terminate the pregnancy. So basically, एम्स ने जब सुप्रीम कोर्ट ने मेडिकल प्रेगनेंसी को टर्मिनेट करने का ऑर्डर पास कर दिया था, उसके बाद भी क्या हुआ था, उसके बाद स्टूडेंट्स ये हुआ था कि वापस से ऑल इंडिया इंस्टीट्यूट ऑफ मेडिकल सर्जरी एम्स ने क्या किया था, वापस से एक पिटिशन फाइल की थी सुप्रीम कोर्ट में टू रिकंसीडर इट्स ओन जजमेंट. बट अगेन द सुप्रीम कोर्ट ऑफ इंडिया हैज सेड दैट यू हैव टू टर्मिनेट द प्रेगनेंसी एंड यू डोंट हैव any option. You have to terminate the pregnancy. Now, this original act, Medical Termination of Pregnancy Act, came into existence in 1971, students. This act came into existence in 1971, and the original act of 1971, Medical Termination of Pregnancy Act 1971, only allowed pregnancies which were up to 20 weeks old, and these pregnancies were allowed to save the life of the pregnant woman. In case of rape or incest, failure of contraception only for the married woman. So basically, this 1971 act, which came for the first time, it allowed only termination of pregnancies which were 20 weeks old, and the second one was कि जो सिर्फ married woman होती थी, सिर्फ उन्हें को termination का right available था. जो अनमैरिड वुमेन होती थी उनको टर्मिनेशन का राइट अवेलेबल नहीं था. बट इन 2021 द ऑनरेबल पार्लियामेंट ऑफ इंडिया और द ऑनरेबल यूनियन गवर्नमेंट ब्रॉट अ वेरी इंपॉर्टेंट अमेंडमेंट इन द 2020 in the 1971 act, and there were certain changes. The upper limit for termination was raised from 20 to 24 weeks for special categories of women, including rape survivors, victims of incest, minors, and women with disabilities. The failure of contraception clause was extended to unmarried women, ensuring they have the same legal right to seek a safe abortion as a married woman. Now, if a medical board diagnoses substantial fetal abnormalities, a pregnancy can be terminated beyond 24 weeks. So basically what happened, students, the union government created three different categories. First category was when the pregnancy was up to 20 weeks old. Second, when the pregnancy was somewhere between 20 to 24 weeks old. And the third one was when the pregnancy is beyond 24 weeks old. So for the first case, it should affect the health of the pregnant woman. And also if there are apprehensions कि जो चाइल्ड जिसका बर्थ होगा उसको कोई सब्सटेंशियल मेडिकल कंडीशन हो सकता है. सेकेंड केस क्या था, जिसमें माइनर्स, रेप सर्वाइवर्स को इंक्लूड किया गया था. और इन दोनों केसेस में बेसिकली फेलियर ऑफ कॉन्ट्रासेप्टिव्स, Now students, let's understand one thing. When it comes to a termination of pregnancy beyond 24 weeks, then you need the approval of, then you need a prior approval of medical board. And let's not forget one more important aspect of medical termination of pregnancy, and that important aspect is that you cannot exercise the termination of pregnancy as a right. This is allowed only under exceptional circumstances. आप कल को जाकर के हॉस्पिटल में ये नहीं कह सकते that this is my body and I have bodily autonomy, I can terminate my pregnancy. There must be certain grounds like failure of contraceptives, or there are some imminent risk to the pregnant woman, to the mother, or to the fetus. These are the only grounds when the termination of pregnancy can be allowed. It cannot be exercised as a part of family planning or bodily autonomy. Three categories: up to 20 weeks old, 20 to 24 weeks old, beyond 24 weeks old. 20 weeks और 20 to 24 weeks old में जो grounds हैं, those are almost similar. आप डॉक्टर के पास जाकर के अपनी प्रेगनेंसी को टर्मिनेट करवा सकते हैं if there is an imminent threat to the child or to the pregnant mother. But when the pregnancy is beyond 24 weeks old, then you need a prior approval of the medical board constituted by the state. Right? Now this was made through 2021 amendment. Now moving on to the next point. The act requires the opinion of one doctor for termination of up to 20 weeks and two doctors for those between 20 and 24 weeks. So basically this was also made clear by through 2021 amendment कि जो first category है up to 20 weeks जो old pregnancy है, वहाँ पे you need the opinion of one doctor. Second category के लिए you need opinion of two doctors. And when the pregnancy is beyond 24 weeks old, then you need the approval of a medical board. और उस medical board में कौन कौन होगा? The medical board must consist of a gynecologist, a pediatrician, a radiologist or sonologist, such other number of members as may be notified by the official gazette by the state. So जो official medical board होगा जो beyond 24 weeks की pregnancy को terminate करना allow करेगा, this particular medical board shall consist of 4 individuals. The first one must be a gynecologist, second one is pediatrician, third one is radiologist or a sonologist, and the fourth one is the other eminent members which are notified through an official gazette by the concerned state government. ठीक है, तो इसीलिए मेडिकल बोर्ड जो है इसका कॉम्पोजिशन इज वेरी इंपॉर्टेंट बिकॉज इट इज एप्लीकेबल इन द करंट केस एज वेल. करंट केस हमारा क्या था? प्रेगनेंसी वाज 30 वीक्स ओल्ड. तो जब 24 वीक्स के बियॉन्ड प्रेगनेंसी होती देन यू नीड अप्रूवल ऑफ द फॉलोइंग people which are the part of the medical board, right? So if you have any particular question from this topic, you may ask your question. Otherwise we'll move to the one of the most important judgment of May 2025, Sayyid Iftikhar Andrabi versus National Investigation Agency Jammu. Sayyid Iftikhar Andrabi versus National Investigation Agency Jammu, and this is one of the most important judgment for CLAT 2027, keeping in mind that it is directly related to Article 21 and 22 of the Indian Constitution, which is part of your syllabus in legal reasoning and also in static GK, right? So बहुत attention के साथ इस particular topic को हम cover करेंगे, and today I'll give you a very sound reasoning of patience, ki why you need to have a lot of patience while preparing for any examination, right? So let's start with this particular judgment. The title of this particular case is Sayyid Iftikhar Andrabi versus National Investigation Agency Jammu. Now students, there is a provision in Unlawful Activities Prevention Act of 1967. अब Unlawful Activities Prevention Act 1967 के हम किस प्रोविजन की बात करें? So let's talk about this particular provision of Unlawful Activities of Prevention Act 1967. This particular provision is basically section 43D clause 5 of UAPA 1967. And what is section 43D clause 5 of UAPA 1967? So let's understand what is section 43D clause 5 of UAPA 1967. कहीं पर कोई भी question होता है, please don't hesitate, ask your question. This session is absolutely for you guys. You have all the available rights to ask questions, right? Now what is section 43D of UAPA 1967? So basically the court shall deny the bail if it has reasonable grounds to believe that prima facie accused was involved in the commission of the offense, right? This is section 43D clause 5 of UAPA 1967. Now students, what is the main issue with section 43D clause 5 of UAPA 1967? Anyone who would like to answer the question? It is a 5-star question. So if a medical board have allowed the teen for the medical termination of pregnancy without even coming up to the Supreme Court, so would that be enough for her medical? Yes, absolutely. In every case, you don't need to approach the Supreme Court. The Supreme Court has said that when it is a case of when the case is related to the survivor of a rape or the victim is minor, and in that particular case the choice of family members and the minor will prevail over doctors and the state. So the concerned medical board can allow the termination of pregnancy without approaching to the court, right? In this case the All India Institute of Medical Surgery Medical Sciences approached the court because they don't want this pregnancy to be terminated, क्योंकि उनका opinion ये था that this particular pregnancy is absolutely fit and healthy, right? So section 43D clause 5 of UAPA 1967 क्या करता है कि वो कोर्ट से ये बोलता है कि भाई अगर आपको लगता है, if you believe that the the accused was primarily involved in the commission of the offense, then in every case you shall deny the bail. Absolutely fine, there is no problem with that. But again, the problem is section 43D clause 5 shifts burden of proof from accused to, from prosecution to accused. Now in normal cases, students, what is the normal principle of criminal law? That the prosecution has to prove guilt beyond the reasonable doubt. So these are the few principles related of criminal law जो आपको पता होने चाहिए. That in normal criminal cases, the prosecution has to prove the guilt of the accused beyond the reasonable doubt. Normally जो burden of proof होता है, that is always upon the prosecution. And lastly, one of the most important principle of criminal law जो हम इंडिया में follow करते हैं, and that principle is innocent until proven guilty. Now the normal principle under criminal law is that the prosecution has to prove the guilt of the accused beyond the reasonable doubt, but section 43D clause 5 shifts the burden of proof from prosecution to accused. कि accused को अगर bail लेनी है तो उसे कोर्ट में ये प्रूव करना होगा that I was not involved in the commission of the offense. और अगर prosecution 0.1% भी ये प्रूव कर देता है that he or she was involved in the commission of the offense, then in every case the court has to deny the bail. Now, while granting bail in Sayyid Iftikhar Andrabi versus NIA Jammu, the Honorable Supreme Court of India made a very important observation. And what was that observation? The observation was that, right to speedy trial is a fundamental right recognized under Article 21. Every accused person deserves a speedy trial. Now, Mr. Sayyid Iftikhar Andrabi was in jail for last 5.5 years and his trial was yet to commence. So the Supreme Court said that it is a blatant violation of Article 21. No specific statutory law can supersede the provision of Article 21. चाहे उसमें कुछ भी लिखा हो सेक्शन 43D क्लॉज 5 में, बट फंडामेंटल राइट्स विल प्रिवेल over every other right. So if the accused has not been given a speedy trial for last 5.5 years, then he deserves a bail, although section 43D clause 5 is there. Because section 43D clause 5 of UAPA 1967 cannot supersede Article 21, which talks about right to speedy trial under Article as a fundamental rights. अब बताइए यहां तक अगर आपको समझ में आया तो हम फिर आगे बढ़ते हैं फटाफट. And after the Supreme Court of India, a division bench of the Supreme Court of India granted bail to Sayyid Iftikhar Andrabi, within a week the Supreme Court granted bail to 6 to 7 more accused who were prosecuted under UAPA 1967. That's the beauty of the Supreme Court of India. कि आपको एक जजमेंट दे करके तो देखिए सारे जजमेंट वैसे पीछे आएंगे. हेलो सर, हाय तरुण, वी शुड कंटिन्यू विद द केस. अगर आपका कोई सवाल है इस केस से तो आप पूछ सकते हैं, अदरवाइज वी हैव अ लॉट ऑफ इंपॉर्टेंट टॉपिक्स टू कवर इन टुडेज न्यूज़पेपर. यहां तक आप सब लोग को समझ में आ गया? यस और नो? अगर समझ में आ गया, लाइक द वीडियो एंड जस्ट ड्रॉप योर रिएक्शन इन द चैट बॉक्स सो दैट वी कैन मूव, बिकॉज दिस इज ऑल्सो वेरी इंपॉर्टेंट फॉर योर एग्जामिनेशन, बिकॉज इट इज डायरेक्टली रिलेटेड टू chapter part 3 of the Indian Constitution, which is fundamental rights, right? Okay, moving on. अब हम आ जाते हैं अपने जजमेंट पे. So the Supreme Court today held that bail is the rule and jail is the exception. Another important principle of the criminal law, that bail is the rule, jail is the exception. क्यों? क्योंकि बिकॉज जब तक पर्टिकुलर किसी अक्यूज्ड को कन्विक्ट नहीं कर दिया जाता है, he is accused, you cannot treat him like a convicted person. AK Kumar, hi Mr. AK Kumar. Right. Now, Act and statutory restrictions on bail under Section 43D Clause 5 cannot override constitutional guarantees under Article 21 and 22. We have already discussed it that although Section 43D Clause 5 is there, but in no case it will supersede Article 21 and 22, because Article 21 talks about right to speedy trial. Right. Moving on. A bench of Justice Ujjwal Bhuyan and Justice B.V. Nagratna. I have immense respect for Justice Ujjwal Bhuyan and Justice B.V. Nagratna. Observe that the principle that bail is the rule was not merely a statutory concept under the CRPC, but a constitutional principle rooted in personal liberty and the presumption of innocence. So we follow presumption of innocence. What is presumption of innocence? कि जब तक accused का guilt beyond reasonable doubt court में prove नहीं हो जाता है, he is an innocent. You cannot treat him like a convict. So his right is to get the bail, and he also deserves a speedy trial. If state is failing to provide a speedy trial, then the accused should not bear the cost of that delay. Getting my point? Okay, fine. Now the often invoked phrase bail is the rule and jail is the exception is not merely an empty statutory slogan. Right, we've got it. It is a constitutional principle flowing from Articles 21 and 22 of the Constitution, and the presumption of innocence, which is the cornerstone of any civilized society governed by the rule of law, the court observed. So every civilized society is governed by a basic principle of law that is known as the rule of law. Rule of law is supreme. Nothing can supersede rule of law, and Article 21 is one of the most important article, or one of the most important provision which talks about the principle of rule of law. Right. Good evening everyone. Let's continue with the session, and this is very important. I'm trying to make it very interesting because somebody in the last session said कि sir हम थोड़ा सा क्या session को interesting बना सकते हैं. So I'm trying to make it immensely interesting for you. Now the court clarified that those statutes such as UAPA could impose restrictions on grant of bail in cases involving national security. Such restrictions could not invert the constitutional relationship between liberty and detention. So basically the Supreme Court said कि there are certain special laws which can restrict the right of the accused to get bail, but they can never supersede Article 21 and 22 of the Indian Constitution. Because what is Article 21, students? No one can take your life and personal liberty except the procedure established by law, or procedure established by law क्या कहता है? That you should get a speedy trial. So if a state is if a state has failed to ensure your fundamental rights, then you have absolutely all the rights to seek bail from the court, and the court has to allow it. Getting my point? Yes or no? Can we move ahead? Now this is a very small topic. It will not take more than 2 minutes, and it is extremely relevant for static GK. Let me tell you, it is extremely relevant for static GK, current affairs, ELIT, and all other law entrance examination. Oh, thank you so much, Ankit. Thank you so much for your remark. I'm extremely humbled. Thank you. The President of India has promulgated an ordinance to increase the number of Supreme Court judges from 33 to 37, and all the best for your bright and shiny future. I wish you all the luck. The President of India has promulgated an ordinance to increase the number of Supreme Court judges from 33 to 37, excluding the Chief Justice of India. So we know this. Recently, the President of India, Draupadi Murmu ji, has promulgated an ordinance by using the powers given under Article 123 of the Indian Constitution. Remember this, Article 123 talks about the power of the President to promulgate the ordinance, and Article 213 talks about the power of the Governor to promulgate the ordinance. Now let me give you a brief background of this particular case. So on 5th of May 2026, the Union Cabinet approved a proposal to increase the strength of the Supreme Court judges from 33 plus 1 to 37 plus 1. Right, now moving on to the next point. But because the House was not in session, so on 16th of May 2026, the President of India has to promulgate the ordinance under Article 123 of the Indian Constitution, right? Up now, the Supreme Court has finally, the Honorable President of India has finally promulgated the ordinance under Article 123, and the strength of the Supreme Court judges has been increased from 33 plus 1 to 37 plus 1. Now, to do this, the name of this ordinance is also very important. The name of this ordinance is the Supreme Court Number of Judges Amendment Ordinance 2026. Please ये पूरी की पूरी लाइन आप इसी तरीके से याद रखेंगे. What was the title of the ordinance which was passed by the Honorable Supreme Court of India? The Supreme Court Number of Judges Amendment Ordinance 2026 was promulgated to amend Section 2 of the Supreme Court Number of Judges Act 1956 to replace word 33 therein with 37. तो अभी इसको हम एकदम फटाफट समझ लेते हैं क्या हुआ है. That the President of India has promulgated this ordinance, and after this ordinance, Section 2 of the Supreme Court Number of Judges Act 1956 stands amended. और Section 2 में जो word use किया गया था 33, क्योंकि पहले सुप्रीम कोर्ट के जजेस का स्ट्रेंथ कितना था 33, इट हैज बीन रिप्लेस्ड विद 37, right? As per Article 124 of the Constitution, the Supreme Court comprises of the Chief Justice of India and the number of judges which the Parliament prescribes by way of law, right? So it is the Parliament of India which can fix the strength of the Supreme Court judges, but as the House was not in session, so the President of India has to promulgate the ordinance using the powers given under Article 123. Let me give you a brief background about the पावर टू प्रोमलगेट द ऑर्डिनेंस एज वेल. ऑर्डिनेंस हम कब प्रोमलगेट कर सकते हैं? प्रेसिडेंट कब प्रोमलगेट कर सकता है या गवर्नर कब प्रोमलगेट कर सकता है? व्हेन द हाउस इज नॉट इन सेशन. व्हेन द हाउस इज नॉट इन सेशन. सेकंड इंपॉर्टेंट पॉइंट, द मैक्सिमम ड्यूरेशन ऑफ द ऑर्डिनेंस. ऑर्डिनेंस की मैक्सिमम ड्यूरेशन क्या हो सकती है? सो अब दो चीजें आप यहां पर भी याद रखेंगे, दैट देयर कैन नॉट बी अ गैप ऑफ मोर देन 6 months बिटवीन द 2 sessions ऑफ द हाउस. सो द मैक्सिमम ड्यूरेशन ऑफ एन ऑर्डिनेंस कैन बी, सबसे पहले तो जब हाउस सेशन में नहीं होता तब हम ऑर्डिनेंस लेकर के आते हैं, तो 6 months, क्योंकि 2 सेशंस के बीच में 6 months से ज्यादा का गैप नहीं हो सकता है. नाउ द थर्ड पॉइंट इज दैट वंस द हाउस इज रिकन्वीन्ड or once the house reassembled, there are 3 possible things which can happen. There are 3 possible outcomes. The first one is कि ऑर्डिनेंस अप्रूव कर देगा पार्लियामेंट. अगर अप्रूव कर देता है लॉ बन जाएगा. अप्रूव नहीं करेगा तो ऑर्डिनेंस लैप्स कर जाएगा. और अगर कोई स्पेसिफिक डिसीजन नहीं लिया जाता है, देन within 6 weeks from the date on which the house was reassembled, from the date on which the house was reassembled, the ordinance will lapse. So the maximum duration of an ordinance can be 6 months and 6 weeks. Getting my points? Yes or no? Yes or no? Getting my points? ठीक है, तो ये हो गया आपका एक ऑर्डिनेंस का एक ब्रीफ बैकग्राउंड. आर्टिकल नंबर प्लीज याद रखिएगा, इट्स वेरी इजी, 1 2 3 1 2 3, एंड फॉर गवर्नर इट्स 2 1 3, राइट? सो दैट्स इट. अब अगर आपका कोई इस टॉपिक पे सवाल है तो आप फटाफट पूछ लीजिए, बिकॉज आई एम ओपन टू आंसर ईच एंड एवरी क्वेश्चन. आई रियली वांट कि जब आप इस क्लास से निकल करके जाएं, यू आर एक्सट्रीमली सेटिस्फाइड, और आप हर एक सेशन अटेंड करें. बिकॉज सी आई रियली वांट कि जब आप 6 December को क्लैट 2027 का एग्जाम लिख रहे हो, तो आपने मैक्सिमम चीज़ें हमारे साथ सेशंस में कवर की हों, और आप एग्जाम देने के तुरंत बाद बोलें अच्छा है सेशंस अटेंड कर लिए थे, राइट? एंड आई विल गिव यू अ वेरी फाइन लॉजिक. अभी आज मैं कैप लगा करके आया हूँ. एट द एंड ऑफ दिस क्लास आई विल मेक इट एक्सट्रीमली फनी फॉर यू, राइट? सो बताइए, अभी हम आगे बढ़ सकते हैं? यस और नो? जस्ट गिव योर रिस्पॉन्स. And on Saturday we have a quiz. After the Hindu analysis session we have a quiz, right? तो उसमें भी participate करना है, क्योंकि वो quiz पूरा इस week में जितनी भी चीजें हुई हैं उनको लेकर के होगा, right? So can we move ahead? अरे 9 students are watching. At least one should respond, so I can proceed. Now, criminal law and matrimonial presumption is statutory presumption affirmed in dowry death bail, please. No, Tanmay, there is no update on Indus Water Treaty. This treaty, which was signed in 1960, is still in abeyance. India suspended this treaty last year after Pahalgam attack, and there is no update at all on Indus Water Treaty. जो मुझे लास्ट पता था, अगर आज या कल में कोई अपडेट आया, so I'm not aware about that. But अगर अभी तक मतलब till 2nd of June there was no update on Indus Water Treaty, right? Then what is this case? Mahesh Chand versus State of UP. It was decided on May 11th, 2026. So the Supreme Court aggressively cancelled a bail order previously granted to an accused party by a lower court in a tragic case involving a dowry death. Now students, जो minor topics legal reasoning में आपसे पूछे जाते हैं, उसमें से हो सकता है कि dowry death से related cases भी आपसे पूछ लिए जाएं, क्योंकि recently जो भोपाल में ट्विशा, हाँ मतलब उस पर यही था ना कि परमानेंट कोर्ट ऑफ आर्बिट्रेशन के पास अगर वो उसमें जो पूरा मैकेनिज्म क्रिएट किया गया था इंडस वाटर ट्रीटी में, उसमें फाइनल सोल्यूशन यही था कि परमानेंट कोर्ट ऑफ आर्बिट्रेशन के पास मैटर जाएगा। और अब इंडिया ने अगर रिजेक्ट कर दिया, क्योंकि उसमें एक ये भी क्लॉज था दैट द डिसीजन गिवन बाय द परमानेंट कोर्ट ऑफ आर्बिट्रेशन विच वॉज एस्टैब्लिश्ड इन 1899 इन हेग इज बाइंडिंग, राइट, इज बाइंडिंग, राइट। सो लेट्स, I don't know what will happen, but I'll see into it and I'll let you know कि what is the latest update, right? So अभी जो ट्विशा शर्मा वाला केस हुआ था स्टूडेंट्स भोपाल में, that can be a perfect case study for your legal reasoning, और ये डाउरी डेथ से ही रिलेटेड है। अब हुआ क्या है कि करंट केस में एक ट्रायल कोर्ट था जो वो पूरा डाउरी डेथ का केस था, उसको वो ट्रायल कंडक्ट करवा रहे थे, उस ट्रायल कोर्ट ने अक्यूज्ड को बेल दे दी। नाउ द प्रोसिक्यूशन वेंट इन अपील टू द सुप्रीम कोर्ट, and Supreme Court very aggressively asserted, and what was the opinion given by the the Honorable Supreme Court of India? The bench ruled that bail cannot be handed down on weak tenuous grounds such as superficial readings of a cause of death or mild procedural delays in filing an FIR when dealing with dowry deaths. So the Supreme Court of India has said that the Indian criminal justice system is tilted towards the accused, because it is the prosecution which has to prove the guilt of the accused beyond the reasonable doubt. So अगर कोई dowry death का केस है, तो you don't have to, the trial court does not required to read between the lines. उसको जो minor procedural delays होते हैं उनको consider नहीं करना। अगर FIR फाइल करने में डिले हुआ है, so these facts are very small to consider them as a ground for granting bail when it comes to the cases related to dowry death. The Supreme Court held that if there is a clear prima facie evidence of cruelty and death occurs within 7 years of marriage, courts must rigorously apply the strict statutory presumption under section 118 of the Bharatiya Sakshya Adhiniyam, formerly section 113B of the Evidence Act. So basically students, section 118 of the Bharatiya Sakshya Adhiniyam is basically presumption as to dowry death. अगर within 7 years डेथ हुई है वाइफ की, एंड देर आर क्लियर एविडेंसेस ऑफ क्रूएलिटी, and evidences are that the in-laws were demanding dowry, then there will always be a presumption that the families of in-laws was involved in the dowry death, और उससे उस केस में बेसिकली ट्रायल कोर्ट को बेल ऐसे इररेलेवेंट और टेनियस ग्राउंड्स पर नहीं देना है। दे शुड कंसीडर द प्रिजम्पशन गिवन अंडर सेक्शन 118 ऑफ भारतीय साक्ष्य अधिनियम विच टॉक्स अबाउट प्रिजम्पशन एज टू डाउरी डेथ। अगर 7 years के अंदर मैरिज हुई है एंड देयर आर एविडेंसेस ऑफ क्रुएलिटी, देन द केस विल टिल्ट टुवर्ड्स इन द फेवर और टिल्ट इन द फेवर ऑफ विक्टिम, राइट। नाउ लेट्स मूव टू द नेक्स्ट पॉइंट। Supreme Court issues comprehensive victim protection plan for human trafficking survivor, calls for legislative reforms. Now in this case, the Supreme Court of India has also made one important observation, Prajwala versus Union of India students, and that Prajwala versus Union of India mein the important observation is that voluntarily I mean I'll tell you when we are in that specific area, I'll explain it to you in detail that what are we talking about. So basically so these guidelines are basically issued by the Supreme Court of India in cases related to or in cases involving human trafficking and commercial sexual exploitation. Now in India students, the situation of the survivors of human trafficking victims is grave. There is no comprehensive plan or guideline how to rehabilitate the life of these survivors of commercial sexual exploitation and human trafficking survivors. So in this particular regard, keeping the human emotions and human empathy, the Supreme Court has delivered a very comprehensive guidelines in the case of Prajwala versus Union of India. Now, in a landmark judgment addressing human trafficking for commercial sexual exploitation, the Supreme Court has issued a comprehensive victim protection plan and directed all states and union territories to implement a series of measures aimed at protecting and rehabilitating trafficking survival. अब ये जो order है Supreme Court ने issue किया by using the powers given under Article 32, and what is Article 32? Writ jurisdiction of the Supreme Court, that the Supreme Court of India can issue 5 writs for the enforcement of fundamental rights, and Article 142 is power to do complete justice. Now, अभी विक्टिम प्रोटेक्शन प्लान एक कॉम्प्रिहेंसिव विक्टिम प्रोटेक्शन प्लान डिवाइस करने के लिए बोला. द बेंच ऑब्जर्व दैट डिस्पाइट द एक्जिस्टेंस ऑफ मल्टीपल लॉज डीलिंग विद ट्रैफिकिंग एंड सेक्सुअल एक्सप्लॉयटेशन, इंडिया लैक्स अ कॉम्प्रिहेंसिव एंड बाइंडिंग फ्रेमवर्क. सो द प्रॉब्लम इज वी डोंट हैव अ बाइंडिंग फ्रेमवर्क when it comes to the survivors of the human trafficking and the commercial sexual exploitation. So the Supreme Court has basically kind of requested that please states, please consider making a comprehensive binding plan for the survivors of the human trafficking and commercial sexual exploitation, impairing and this non-uniform treatment, because there is no common law for or no uniform law across India. So it basically creates a kind of non-uniform treatment of the survivors, and it actually violates Article 21 and 23. Article 21 is again right to life and personal liberty, and Article 23, what is Article 23? Bonded labor, right? The court noted that while the union government had earlier acknowledged the need for a victim protection plan and had undertaken efforts to formulate one, no such framework had been finalized. So the next problem issue raised by the Honorable Supreme Court of India is that no comprehensive plan is formalized by the union government till this date. So they have to make a binding and final comprehensive plan for the entire country. And finally, this is the statement which I was talking about. आपको याद रखना, प्रज्वला वर्सेस यूनियन ऑफ इंडिया में ये स्टेटमेंट दिया गया था. Voluntary adult sex workers must not be criminalized unnecessarily, right? So if these adult sex workers, if they are doing it voluntarily, then the authorities must not harass them unnecessarily. उनके against criminal prosecution initiate नहीं करना चाहिए, because at the end of the day, if you read the entire judgment, I mean, you will feel that the Supreme Court is trying to say कि nobody wants to do it, but there are certain situations जहाँ पर आप जो adult sex workers होते हैं वो उसे voluntary करने लगते हैं. तो अगर ऐसा कोई केस है तो अथॉरिटीज को वहाँ पे unnecessarily criminal prosecution initiate नहीं करना चाहिए. और जितने भी अलग अलग अथॉरिटीज हैं उनको इंटीग्रेट करने के लिए सुप्रीम कोर्ट ने बोला है कि जुवेनाइल जस्टिस एक्ट, पॉक्सो एक्ट, एंटी ट्रैफिकिंग रिजीम, चाइल्ड वेलफेयर बोर्ड, एंटी ट्रैफिकिंग, एंटी ह्यूमन ट्रैफिकिंग यूनिट्स, लीगल एड अथॉरिटीज, सबको इंटीग्रेट करके एक कॉम्प्रिहेंसिव प्लान बनाना चाहिए. क्योंकि कई बार जब व्हेन इट कम्स टू ह्यूमन ट्रैफिकिंग, लोग क्या करते हैं, अथॉरिटीज एक दूसरे के ऊपर उस पूरे केस को क्या करते रहते हैं, शिफ्ट करते रहते हैं कि नहीं ये इनकी रिस्पॉन्सिबिलिटी थी, ये इनकी रिस्पॉन्सिबिलिटी थी. अब नाउ द लास्ट टॉपिक फॉर द डे, एंड इट इज ऑल्सो वेरी इंपॉर्टेंट, इट इज रिलेटेड टू सेडिशन लॉ. सेडिशन लॉ से रिलेटेड है, और इसके बाद बेसिकली हम इस पूरे सेशन को रैप अप करेंगे. सो लेट्स टॉक अबाउट दिस लास्ट टॉपिक दैट वी हैव टू कवर. सो रिसेंटली अभी इसमें हमें एक टाइमलाइन भी फॉलो करनी पड़ेगी. वी हैव टू फॉलो अ टाइमलाइन. Revival of sedition law in India. Now, what happened? So let's talk about this particular case. So recently in Kamran versus State of Madhya Pradesh, the Supreme Court has said that if may 2026. If the accused is willing, then he can continue with the prosecution. Sorry, he can continue with the trial, and also it can file, he or she can file an appeal. Now, after this particular order was passed by the Supreme Court, ki agar if the accused is willing, then he can continue with the trial, and also it can file an appeal when he or she is prosecuted for committing offense under sedition. Now, sedition was basically student section 124A of Indian Penal Code. Now, this particular judgment was passed by the Honorable Supreme Court of India in May 2026. अब अगर सुप्रीम कोर्ट ने ये टर्म यूज किया कि कैन कंटिन्यू, तो इसका मतलब क्या है कि इसके पहले जो ऑर्डर पास किया होगा उसमें इस पूरे चीज को पॉज कर रखा होगा, राइट? गेटिंग माय पॉइंट? तो अगर पॉज कर रखा है तो वो जजमेंट कौन सा था? सो बेसिकली दैट जजमेंट वाज SG Wombat-Kere versus Union of India. Now, in this particular judgment, student, in SG Wombat-Kere versus Union of India, students, the Honorable Supreme Court of India in 2022 suspended operation of Section 124A of IPC, and it paused all the hearings and cases related to Section 124A of IPC, and it also ordered the government to review sedition law. Now, what is sedition, students? What is sedition? तो पहले sedition समझ लेते हैं. What is sedition? So sedition is basically when through words spoken or written or signs or by visible representation one is trying to bring hatred or disaffection towards the government established by law. Now, students, normally sedition law section 124A, now Indian Penal Code has been replaced with Bharatiya Nyaya Sanhita, so nothing that important in that context, but again this is very important. So जब आप गवर्नमेंट के टुवर्ड्स हेट्रेड या डिसअफेक्शन लाने की कोशिश करते हैं थ्रू योर वर्ड स्पोकन और रिटन और कोई विजिबल रिप्रेजेंटेशन या कोई साइन के थ्रू, तो बेसिकली वो क्या होता है? दैट विल अमाउंट टू सेडिशन, एंड दिस इज नोन एज ड्रैकोनियन लॉ. ड्रैकोनियन लॉ क्यों बोलते हैं? बिकॉज इसके पीछे एक बहुत अच्छी और इंटरेस्टिंग हिस्ट्री है. हिस्ट्री क्या है? फॉर द फर्स्ट टाइम इट वाज कॉन्स्टिट्यूटेड ड्राफ्टेड इन 1837, फिर फाइनली 1860 में जब इंडियन पिनल कोड आया, सो उसमें सेडिशन लॉ को कोई जगह नहीं मिली, बट फाइनली it was inserted in the Indian Penal Code. it was finally inserted in Indian Penal Code in 1870 through an amendment. So 1837 में जब लॉर्ड मैकॉले ने सबसे पहला इसका ड्राफ्ट रेडी किया, फिर 1860 में जब उन्होंने इंडियन पिनल कोड ड्राफ्ट किया, और फाइनली उस समय उसको कोई प्लेस नहीं मिला इंडियन पिनल कोड में, बट 1870 में थ्रू एन अमेंडमेंट सेडिशन वाज इंसर्टेड इन द इंडियन पिनल कोड. और क्यों इंसर्ट किया था? क्योंकि 1857 के बाद, फर्स्ट वॉर ऑफ इंडिपेंडेंस के बाद, ब्रिटिश क्राउन के अगेंस्ट बहुत ज्यादा लोग एजिटेट और प्रोटेस्ट करने लगे थे, तो उस चीज को कंट्रोल करने के लिए सेडिशन लॉ एग्जिस्टेंस में आया था. नाउ स्टूडेंट्स, एट द सेम टाइम आफ्टर द सुप्रीम कोर्ट ऑफ इंडिया रिक्वेस्टेड इन एसजी वॉम्बत केरे वर्सेस यूनियन ऑफ इंडिया द गवर्नमेंट ऑफ इंडिया टू रिव्यू सेडिशन लॉ, तो गवर्नमेंट ने क्या किया फिर? गवर्नमेंट ने क्या किया, जब वो 2023 में भारतीय न्याय संहिता लेकर के आते हैं, तो उसमें वो सेक्शन 124A आईपीसी को रिप्लेस कर देता है. इट वाज रिप्लेस्ड विद सेक्शन 152 ऑफ भारतीय न्याय संहिता. इंटरेस्टिंगली सेक्शन 152 में does not use the word सेडिशन. बट कंपेयर कर लेते हैं, सेक्शन 124A ऑफ आईपीसी में जो पनिशमेंट थी, दैट वाज 3 years to up to life imprisonment. और सेक्शन 152 में क्या था? 7 years to up to life imprisonment. सो बेसिकली क्वांटम ऑफ पनिशमेंट बढ़ा दिया पार्लियामेंट ने, बट सेडिशन वर्ड का यूज नहीं किया. अब कामरान, अब 2022 में सुप्रीम कोर्ट ने क्या किया था? सारी जो प्रोसीडिंग्स थी उनको पॉज कर दिया था, उनको सस्पेंड कर दिया था. विल डू दैट एमिटी गेमिंग विल डू दैट, अमित वाइटी गेमिंग विल डू दैट, राइट. बट अभी हम इस टॉपिक पे फोकस करते हैं. सो दिस इज द लास्ट स्टेटमेंट, and with this we are done with this today's session. So basically क्या हुआ, 2022 में सुप्रीम कोर्ट ने सेक्शन 124A से रिलेटेड जितनी भी प्रोसीडिंग्स थी उनको सस्पेंड कर दिया, बट वापस से 2026 में सुप्रीम कोर्ट ने बोला कि अगर कोई अक्यूज्ड है उससे वापस से अपील फाइल करना है और या उसे ट्रायल अपना रीस्टार्ट करवाना, देन ही और शी कैन डू सो, बिकॉज देयर वाज अ पर्सन, देयर इज एन अक्यूज्ड हु इज इन जेल फॉर लास्ट 17.5 years. He was prosecuted under section 124A of IPC and he want to file an appeal related to the offense of sedition. So basically सुप्रीम कोर्ट ने वापस से रिवाइव कर दिया. इसका बैकग्राउंड ये है, सेक्शन 1837 में ड्राफ्ट किया गया था, 1860 में आईपीसी आया, 1870 में इसे इंसर्ट किया गया इंडियन पिनल कोड में, 2022 में इसका ऑपरेशन सस्पेंड किया गया, 2026 में इसे रिवाइव किया गया. मैक्सिमम पनिशमेंट अंडर सेक्शन 124A was 3 years to up to life imprisonment, and under section 152 years, under section 152 of BNS 7 years to up to life imprisonment. But section 152 में sedition word का यूज नहीं किया गया. And this is it. This is all about this particular topic. तो आपको मुझे एग्जाम्पल ये देना था. I mean, this can be very shocking for you. So day before yesterday a tragedy took place and ultimately I have to get my head shaved. So basically अभी जिन लोगों ने CLAT की प्रिपरेशन स्टार्ट नहीं किया उनका सिचुएशन अभी बिल्कुल ऐसा है, राइट. विद इन 2 to 3 months आई विल गेट माई हेयर्स बैक. अभी मैं इस पर ऑयलिंग करूंगा प्रॉपर, इनको रोज वॉश करूंगा, इनकी प्रॉपर केयर करूंगा, आंवले खाऊंगा, तो ये वापस से आ जाएंगे, राइट. तो अभी जो सिचुएशन है उससे जो डिजायर्ड सिचुएशन है वहां तक पहुंचने के लिए मुझे क्या करना होगा? बहुत ज्यादा एफर्ट्स देने होंगे, राइट. बट वो जो मेरे बाल हैं, जैसा आप लोग पहले देखा करते थे पहले के सेशन में, वो वापस से वैसे आ जाएंगे. तो आइडिया यही है कि अगर आपको सिलेक्शन लेना है, तो अभी अगर आप ऐसे हैं तो आप अगर डेली थोड़ा बहुत मेहनत करेंगे, शैम्पू, नॉट एक्चुअली शैम्पू की, अगर आप प्रीवियस अपना रिविजन करेंगे, कंसिस्टेंटली एक टाइम टेबल फॉलो करेंगे, सो यू विल get what you want, right? So nobody can stop you, right? So on that note, I'll try to wrap up today's session, and if you have loved this session, please do like the video and also recommend it to your friends. And that's it, this is all about today's session. Thank you so much guys for watching this video. I'll see you tomorrow at 7:45 in the morning with the analysis of the Hindu. And that's it from my side. And just one thing to end this session with, that जब आंखों में अरमान लिया, मंजिल को अपना मान लिया, फिर मुश्किल क्या और आसा क्या, जो ठान लिया वो ठान लिया. थैंक यू सो मच फॉर गिविंग मी योर प्रीशियस टाइम. आई विल सी यू टुमारो एट 7:45 in the morning. Bye bye, good night. Bye bye, good night, and take a good care of yourself and people around you. Keep yourself hydrated, and that's it. I'll take your leave now. Bye.